Good morning. How are you guys this morning?
Good morning.
We're back. Okay. I'd like to call to order at 9 a.m. My name is Ariel Pei. It's July 21st, 2022 Enforcement Program Oversight Committee meeting. The CBA has provided the opportunity for public comments to participate via WebEx platform. When we take public comments, we'll begin by taking public comments from those individuals attending the meeting at the California Board of Accountancy headquarters. I will then ask the moderator to open up the lines for public comments. You will have an allotted up to 5 minutes for public comment. Ms. Reed?
Nancy Corrigan.
Nancy Corrigan, present.
Luz Molina Lopez.
Luz Molina Lopez, present.
Dee Dee Owens.
Dee Dee Owens, present.
Ariel Pei.
Ariel Pei, present.
Joseph Rosenbaum.
Joe Rosenbaum, present.
We have a quorum.
Thank you. The CBA's mission is to protect consumers by ensuring only qualified licensees practice public accountancy in accordance with established professional standards. This mission is derived from the statutory requirements that protection of the public shall be the highest priority of the California Board of Accountancy in exercising its licensing, regulatory, and disciplinary functions. Whenever the protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. Okay, at this time, agenda number 1, public comments. So I will now open it up for public comments. Are there any members of the public who would like to make a public comment? Seeing none. Moderator, please open up the lines for public comment.
This is the moderator. I've opened up the Q&A. Members of the public, if you would like to participate, you can click on the question mark inside of the square and type comment in the text field, or I would like to make a comment, and send it to all panelists. No requests have been submitted. Would you like me to close the Q&A feature?
Yes, thank you. Okay, agenda item number 2, approval of the minutes of September 23rd, 2021 Enforcement Program Oversight Committee meeting. Does any member want to make a motion?
Yes, I'll make a motion to approve the minutes.
Is there a second?
Yes, I will second that motion. Thank you.
Are there any questions or comments from our members? Yes.
Excuse me, Chair Pei, I just want to confirm, if I'm not present at the meeting in September, then I should abstain from approving the minutes. Is that correct?
Correct. So actually, my bad, I forgot to note. Please note that if a member observed the meeting and read the minutes that are now on the EPOC, they can vote on the minutes.
Thank you.
So I have a first and I have a second. I will now open it for public comment. After none. Moderator, please open up the lines for public comments.
This is the moderator. The Q&A is open. Instructions are on the screen. You can click on the question mark inside of a square and type, I would like to make a comment in the text field, and send it to all panelists. No requests have been submitted. Would you like me to close the Q&A feature?
Yes, thank you. Ms. Reed, please take roll.
Nancy Corrigan? Yes. Luz Molina Lopez?
Yes.
Dee Dee Owens?
Yes.
Ariel Pei?
Yes.
And Joseph Rosenbaum?
Abstain.
And the motion carries.
Thank you. Number 3, overview of the enforcement process. Dominic Franzella, Chief of Enforcement Division.
Thank you. Good morning, members. So for agenda item 3, the purpose is to provide members with an overview of the enforcement process. So I'll be focusing primarily on attachment 1, which provides a fairly comprehensive overview of the process from complaint receipt to the various outcomes of an enforcement matter. So to begin with, a bit about the role about the CBA members. Members serve as the decision makers during the enforcement process. So as required by the Administrative Procedure Act, there must exist separation between the adjudicative functions and the investigative, prosecutorial, and advocacy functions of the agency. So CBA members cannot serve in roles during the investigative phase and then be part of the final decisions on a particular enforcement matter. The CBA receives complaints from a wide range of sources: consumers, professional societies, law enforcement agencies, other governmental agencies, but also we do generate a considerable amount of internal referrals that come from a lot from the licensing program, various CBA committees, as well as within the enforcement program itself. The types of complaints the board receives are generally negligence, failing to conform to professional standards, fraud, misappropriation of funds. This year, a large volume of unlicensed activity. We also get various administrative violations, such as failing to complete continuing education or failing to comply with peer review. And when we receive complaints, or when we receive these complaints in, at the initial intake screen, staff evaluate these complaints and place them into one of 3 categories: high, standard, and actionable. And these definitions related to these 3 categories are found on pages 2 and 3 of attachment 1. For completing our investigations, we have a variety of resources that we rely on, primarily internally, both technical and non-technical staff. Our non-technical staff, which we commonly refer to as enforcement analysts, handle the less complex investigations, such as criminal convictions, administrative violations, unlicensed activities, things of that nature. While our technical staff, which are commonly referred to as investigative CPAs or ICPAs, handle the complex investigations involving gross and repeated acts of negligence, embezzlement, failing to conform to professional standards, things of that nature. But the enforcement program does have other tools that we have at our disposal to help. If necessary, we can contract with an outside CPA or an outside expert. If we don't have that technical expertise on staff, we can refer matters to the Department of Consumer Affairs Division of Investigation, which they have a whole staff of peace officers and can aid in some of our more difficult unlicensed practice cases. We can also engage the Attorney General's office to aid in planning and conducting investigations in some fairly highly complex matters. And this is something that's often referred to as vertical enforcement. But honestly, the most beneficial resource the enforcement program has at its disposal is the Enforcement Advisory Committee, which I have Chair Aguilera here today with us, and he'll be providing a role of the EAC, and also I'll defer any kind of overview about the EAC that exists within this attachment to Mr. Aguilera. And additionally, one of the best resources the enforcement program has in conducting some of the really complex investigations is requiring licensees to appear before the EAC and before the EAC and staff in what's known as an investigative hearing, or an IH. Again, Chair Aguilera will cover that in more detail under his presentation. But overall, the purpose of our investigative process is fact gathering. And from the facts that we gather, the enforcement program will make assessments on whether various violations of the California Accountancy Act, CBA regulations, or both have occurred. And at the conclusion of investigation, one of 3 outcomes occurs: closure, issuance of a citation, or referral for formal discipline. Closure will occur when there is either insufficient evidence of violations of the Accountancy Act or regulations, or if there's mitigating circumstances that would warrant closure. Citations are issued generally for administrative type violations. An overview of the citation process is found on pages 4 and 5 of attachment 1. And it's important to note that citations are not considered discipline. Rather, these fall under the general banner of enforcement actions. Citations are issued by the board's executive officer and generally included administrative fine ranging from $100 to $5,000, which is the maximum allowable. And for citations, licensees can appeal a citation, and if it's not settled or the appeal withdrawn, the matter would proceed to an administrative hearing that would be heard by an administrative law judge who will issue a proposed decision. And in this instance, this is where the board would have some role in the citation process. The board would evaluate these proposed decisions and either adopt or non-adopt the citation. However, it is pretty rare, exceedingly rare, that citations generally make it all the way to the board. Most are handled through the general appeal process. For those matters that proceed to referral for formal discipline, fairly comprehensive review of this is found on the majority of the document, pages 5 through 11 of attachment 1. A couple of things to highlight. Referrals for formal discipline are sent to the Attorney General's office for preparation of an accusation. I think this is an important component that members understand that while we may find and determine that there's a violation or believe there's sufficient evidence of violation, that also has to be concurred with by the AG's office. They have to evaluate the totality of our investigative file, the evidence we have, and agree with that particular finding of our staff, and then file the accusation. And in the 7+ years I've been doing this, I think I've had one particular, one matter that I can think of where we had to either do additional investigation or was returned to us because the AG's office didn't agree. So by and large, almost exclusively, the AG's office agrees with staff's assessment of our investigations. So the accusation is a formal pleading that lays out the jurisdiction, the statutory regulatory provisions, kind of the grounds for the various allegations that are alleged in the accusation. And the accusation provides the beginning of really the due process rights of the licensee to contest those allegations in the accusation. The licensee will have 15 days to file a notice of defense contesting the accusation. And additionally, a licensee has a right to representation by counsel at their own expense. Accusations are generally resolved in one of three ways: a default decision, a stipulated settlement, or a proposed decision. And pages 7 through 10 provide detailed information on these resolutions, but at a high level, a default decision occurs when the licensee fails to file a notice of defense. A stipulated settlement occurs when the parties involved reach an agreed upon outcome to resolve the matter. And a proposed decision occurs when the matter isn't settled and proceeds to an administrative hearing where an administrative law judge hears the case and it prepares a proposed decision for CBA members' consideration. So the last area I'd like to highlight in attachment 1 relates to cost recovery, which members can review on pages 11 and 12. Costs are the reasonable cost of an investigation and prosecution of the matter. These only occur in these only are ordered and assessed in either stipulated settlements or proposed decisions. When it comes to stipulated settlements, negotiation of costs recovery, that discussion are often an effective tool in reaching settlement. So in kind of summarizing this up, the last thing I'd like to highlight is attachment 2 relating to the disciplinary guidelines and model orders. The guidelines are designed to be used by administrative law judges, attorneys, CBA licensees, and others involved in the disciplinary process. The guidelines cover model orders, including factors to be considered in aggravation and mitigation, standard probationary terms, and guidelines for specific offenses. The guidelines for specific offenses reference the statutes and regulation provisions that were violated. It's important to emphasize that these are guidelines and deviations do occur as each case is evaluated on a case-by-case basis. So at this time, I'd like to turn discussion back over to Chair Pei, and we'll do my best to answer members' questions as it relates to item 3.
Thank you, Mr. Franzella. Are there any questions or comments from our members? Yes.
Thank you, Chair Pei. Good morning. Thank you, Mr. Franzella, for this presentation. My question has to do with the cases that conclude in closure status. Have there been any of these cases that come up to the board for consideration, or is closure just solely done before it ever reaches the board?
Closure is a function of the enforcement program under the kind of prosecutorial discretion banner, so they're not handled at the board level.
Okay, thank you. And I understand they become closed due to insufficient evidence or lack of jurisdiction or compliance. When there are cases or allegations or whatever that come up and they become closed, how is that communicated to the person who had submitted the initial complaint?
So both the licensee and the complainant, if there is in fact a complainant, and we know the complainant because complainants can submit their complaints anonymously, they would receive a closure letter.
Do they have an opportunity to provide further evidence or any of the other?
Yeah, so just because the matter is closed doesn't mean it remains closed. If additional information, evidence is provided to us, we'll evaluate that information and make a determination whether or not it's sufficient to warrant the matter to be reopened. So it's not uncommon, but it's not incredibly common that we end up having to deal with that.
Okay, and this is communicated to the complainant that they are able to bring this back should further evidence come up or whatever.
Yeah, the closure letter includes information related to either that we found there was insufficient evidence or we're closing the matter, and that if there's additional information that they have or they could become in possession of, they're welcome to submit for our consideration. And they also have an opportunity to provide feedback through DCA has a survey, and that's included in there, and they can provide, and oftentimes that's where they provide some additional information through the survey as opposed to contacting the board again with the additional information. So we evaluate those as well.
Very good, thank you.
Thank you. Yes, Ms. Corrigan.
Mr. Franzella, of all those cases that are closed and don't go any further or come to the board's attention, I believe there's also an oversight function by the Enforcement Advisory Committee to review some of those closed case files. Is that correct?
Yes, I won't touch on it too much because I do know it's part of Chair Aguilera's report, but we do bring a selection of closed case files to the EAC for its review, and these are generally going to be the more technical files, technical type investigations that they would have an opportunity to kind of make a review and make some provide additional information to staff about.
Thank you. I will now open it up for public comment. Are there any members of the public who would like to make a comment? Seeing none. Moderator, please open up the lines for public comments.
The Q&A is now open. The instructions are on the screen. If you would like to participate, click on the question mark inside of a square and type, "I would like to make a comment," and send it to all panelists. No requests have been submitted. Would you like me to close the Q&A feature?
Yes. Thank you. Thank you, Mr. Franzella. Number 4, overview of the role and responsibilities of the Enforcement Advisory Committee, Mr. Doug Aguilera.
Good morning. My name is Doug Aguilera, and I'm the chair of the Enforcement Advisory Committee. I've had the pleasure of serving on the Enforcement Advisory Committee for 5 years and have had the honor of serving as the chair for almost 3 years now. A little bit about my background. I'm a CPA with 30 years of experience, and as an aside, I graduated from San Jose State, and it was a huge benefit for me that is now available to CPAs or potential CPAs to be able to take the exam in my last semester. Very helpful, because once I started work, it was really difficult to get those last few pieces done. So thank you for all your hard work on that. CPA for 30 years. I have the designation of Certified in Financial Forensics from the AICPA. In other words, I'm a forensic accountant. I also am a Certified Fraud Examiner and have the Chartered Global Management Accountant designation. As a forensic accountant, there are a couple of areas that I work in, and they're generally internal investigations, and litigation support. So the internal investigations over the years, most of it has come at Stanford University. Any financial concerns throughout the university, at the hospitals, or they have a federal lab as well. Additionally, those internal investigations have been at public and private companies. The other half of my work, the litigation support, includes helping attorneys to work their way through complex financial issues. And it can also include expert witness work. And I'll have to tell you that as an expert witness, having that CPA designation is huge. There's just a lot of imputed credibility in that. And then I'll admit in public, I love GAAP. I love generally accepted auditing standards, financial statements, and professional standards. For today's item, I'm here to provide members with some background on the role and function of the EAC, the Enforcement Advisory Committee. So the EAC acts as an advisory committee and assists the CBA in its enforcement activities. It includes serving in a technical advisory capacity to the executive officer and the enforcement program, participating in investigative hearings, or what we refer to as IHs, and reviewing open and closed investigations upon request by the enforcement staff, and providing technical assistance to investigators. Our committee is made up of 13 California licensed CPAs, though we do have one vacancy at the present. Our membership has a wide range of experience from small, medium, and large firms, including members who are well-versed in auditing, taxation, consulting, forensic accounting, business management, and much more. It's rare that an issue will come forth that we don't have an expert to look at the issue. When the CBA appoints members to the Enforcement Advisory Committee, it does so for a 2-year term with the ability to appoint members to a maximum of 4 consecutive terms. For leadership positions of chair and vice chair, the CBA appoints these annually. And I'm sharing now some of my key insights related to my experience. And first and foremost, it's a pleasure to work with Mr. Franzella and being a resource. It's also a pleasure to work with the staff. They're very hardworking, and they take the support of the Enforcement Advisory Committee very seriously. And with the committee, the last 2 years have been a little bit tough. It's been, we open the session virtually. I read at the committee members off of a script, and then we close the hearing. And so the members of the committee have been good sports, hung in there, and now we're meeting in person again. During the pandemic, so one of the primary benefits I find is the opportunity to interact with the board. And during the pandemic, I was able to watch about 3/4 of the meetings, which gave me a greater sense and appreciation of what the board members do and the board's efforts. The CBA president appoints 2 CBA member liaisons to attend EAC meetings. The liaisons from the board keep the EAC informed of emerging issues and recommendations made at the CBA meetings. For this year, the committee liaisons are Ms. Owens and Mr. Pei. Thank you. And then recently we had the pleasure at our recent meeting of having Vice President Salazar stepping into the liaison position to help. It's appreciated when one of the board members comes to our meeting and gives us an update. There's another connection point for us. We generally meet 4 to 5 times annually, with our last meeting being our last meeting was our first in-person meeting in over 2 years. Our meetings consist of an open session where we hear about recent CBA activities and meetings and get an update from the enforcement chief on various enforcement activities. In open session is also where we would discuss any items or topics directed to us by the CBA or one of its committees. The second part of our meetings are conducted in closed session. This is where we do our file reviews and conduct the various investigative hearings. So a bit about the file review. Reviews of open investigation case files provide the staff the opportunity to seek advice and technical expertise from assigned committee members. The earlier it can be diagnosed or the earlier that they can get some feedback, some of that feedback is, oh, don't worry about this, you can go ahead and close it, don't spend any more time on this. And some of it might be, here are the next 2 or 3 things that we think that you should do. And do those things, come back to us if you'd like, or continue on. The closed file reviews are also very beneficial to just validate what the staff has done. I can't remember an instance where we've reviewed a closed file and thought that there should be additional work performed. This collaborative process can include one-on-one discussions with investigators or multiple enforcement advisory committee members and various enforcement staff discussions. So it's collaborative. Using our practical and technical experience and expertise, we offer recommendations on various issues within a case. We may also note our perspective regarding various areas the team may want to explore and gather more evidence, or possibly that the standard of care was appropriate and a case could be closed. These open type file reviews could be cases that are at the initial intake review phase, or ones that may be farther along in the overall investigations and at a point of should we hold a hearing or should we not. As for our closed file reviews, I just discussed this a little bit, this provides members an opportunity to examine the methodologies used by the enforcement team and provide recommendations on possible improvements to the investigative process. And so as a committee member, being able to go through this process of file review gives us a better sense of the enforcement process just by touching and feeling the files. There's just much more tangible, seeing the organization, the layout, identifying those documents that are typically brought forward to us, identifying those documents that are administrative in nature. It gives us a much better idea of the overall process as well. And I like to think that the staff can benefit from the committee members' expertise. It's, I know from my perspective, it's always great to have feedback. I like to say that if I'm the smartest person I know, I'm in trouble. So I'm constantly looking for feedback. I hope that they are as well. And it does seem to be the case. One of the CBA's most powerful tools for its investigations are the investigative hearings themselves that are conducted with the licensees. And for me as a volunteer, this is my favorite part by far. And the hearings are quasi-depositional in nature because there's a court reporter in the room, and we're also working with the Deputy Attorney General, who typically leads it off. Licensees are placed under oath, and the investigative hearings are captured by the court reporter. These hearings include 2 to 3 members of the the Enforcement Advisory Committee, a Deputy Attorney General, and the investigator for the case, along with other enforcement staff as appropriate. Again, it's a collaborative process, but led by the committee members. IHs can occur at any point during the investigative process. Over the past few years, the IHs have occurred at the very beginning of the investigation in order to obtain a better understanding of the underlying facts and to determine if a case really needs to proceed. This process offers the committee and staff valuable insight into a case that may not have been available through more traditional investigative methods. Over the last 2 years, the EAC has adapted the way it conducts investigative hearings. Previously, all investigative hearings were in person. As a result of the telework environment, we've established new protocols and practices and have been able to effectively conduct investigative hearings via the WebEx platform. And I'll let you know, give you a little bit more perspective around the benefits of the investigative hearings and some background. So first and foremost, the staff, the Deputy Attorney General's office, and the committee's preparation are admirable, remarkable. There's a lot of work that goes into getting ready to conduct an investigative hearing. Staff puts together a list of questions, anywhere from 50 to 75. Prior to our investigative hearing, we meet with staff, the Deputy Attorney General, the members of the panel, and we go through the underlying facts, what we're going to try to accomplish, and then provide comments on any of the questions. There's always a lead questionnaire, and the lead questioner has an opportunity to adjust those questions, or quite frankly, sometimes we need to take a sharp right turn because there's something that comes up in this fact-finding process that we just didn't expect. And that is a very valuable skill, being able to go off script, being productive, coming back to the script. Many of our members are able to do that. And then as far as a volunteer contribution, it's really meaningful. It's a fantastic volunteer experience. And probably the most, and I'll end here. So probably the most important thing for us is to treat our fellow licensee with respect and courtesy. And there's no assumption or judgment. We're just trying to elicit the facts and support the staff's process. And I think that we're very successful in that way. Thank you.
Thank you, Mr. Aguilera. Are there any questions or comments from our members? Yes, Ms. Corrigan. Yes.
Thank you. A very excellent presentation, very informative, and a lot of what I recall having served on that committee. But a question, and you might have said it and I might have missed it, when the licensee is involved or a part of the investigative hearing, he or she may have legal counsel present, but the questioning is for the licensee, and again, it's information, it's fact-finding. Is that correct?
Yes, from time to time, the licensee does have counsel. We are still walking through our questions and expecting the licensee to answer all of those questions, but they can and sometimes do have counsel.
Thank you. Nothing further?
Yes. Yes.
Thank you, Mr. Aguilera. I admire you and your work and everything that the members do. I recognize that I've been reading the pink sheets for so long, and now I understand everything that happens before the pink sheet is actually brought to each of the members on the board. So thank you very much. That's fantastic. And if anything, it gives me a lot of confidence in the work that does come out of the committee, and then of course staff, and by the time that we get to reading the pink sheets, it just gives me so much confidence knowing there's been many hours put into the work. So thank you for that. My question has to do with the investigation of materials that you receive. Is it investigating paper-based records, or is it electronic records? If they are paper-based, are they copies? Are they originals? What are some of the parameters around that?
So as a forensic accountant, I'm collecting evidence. That's much like what staff and the committee is doing. And that evidence can be books and records, it can be hard copy documents, it can be invoices, it can be emails, and it can be hard copy or electronic. And so it's all collected and analyzed. And the last piece of evidence, well, maybe not always the last piece of evidence, is the licensee's statement. And in a perfect situation, in a perfect fact-finding situation, everything that we see is internally consistent, and all of the answers that we receive are consistent with the other evidence that we've collected. And then also all the answers from the licensee are consistent from beginning to end. And then occasionally we'll be looking for doctored documents, something that somebody has photocopied and manipulated. Did I answer your question? Is that okay?
Yes.
Great, thank you. I will now open it up for public comments. Are there any members of the public who would like to make a comment? Seeing none. Moderator, please open up the lines for public comment.
This is the moderator. The Q&A is now open. The instructions are on the screen for your reference. You can click on the question mark inside of the square, typically lower right of your WebEx screen, and type, "I would like to make a comment" in the text field and send it to all panelists. No requests have been submitted. Would you like me to close the Q&A feature?
Yes, thank you.
Thank you.
Okay, item number 5, agenda items for next meeting. Nothing, no agenda items for next meeting. Okay, with that, at 9:36, we're adjourned. Thank you.